All right, Mike, you're all set.
Okay, good morning and welcome. I'd like to call the meeting of the Policy and Personnel Committee to order. It is 9 a.m. Stephanie, would you please take attendance?
Yes, thank you. Good morning, everyone. Looks like Ava just joined us. Ava,
Morning.
good morning. Taking roll call.
Present.
Ellen McKitterick,
Present.
Alice Pritchard,
Present.
David Salazar,
Present.
Mike Soltis,
Present.
and Holly Williams will not be joining us. We have a quorum.
Okay, thank you, Stephanie. I would like to welcome and thank the members of the public for attending this morning. First item on the agenda is a review and approval of the July 2nd, 2024 minutes. I'd ask the committee for a review of those minutes and a motion to approve.
So
Motion.
moved.
Second.
Any discussion? All in favor?
Aye.
Aye. All opposed? Any abstentions? The motion carries. Thank you. Next item on the agenda, Aaron, would you please lead the discussion regarding the consolidated policy changes?
Certainly, let me pull up the slide deck. This is the slide deck that Michael shared last month with with a slight amendment. I'll just quickly review it, and then we can take some time for any discussion or questions that you may have now that you've had a couple of weeks to actually review the language, unlike last time. So the first batch of changes that we would like to propose relate to the legislation, Public Act 24.5. Because of that legislation, we are able now to utilize the legislative test rather than the policy test that we had created before. So that required a change in the policy language relating to a municipality. It acknowledges that now tribal employers may participate through an MOU. It also includes the language about other income replacement benefits, as well as the exemption for benefits through the Office of Victim Services. It expands the family violence leave to include sexual assault. It also references our ability to charge interest. And again, we've received feedback that the public libraries already have existing categories where municipal libraries are part of municipalities and association libraries are not. So we're using that change, or we're using that language in our policy. We've made a few other changes just to clean things up. So on the contribution side, we would like to begin doing audits of the contributions. So this is separate from fund recovery, where people don't give us any contributions at all. This is us validating the contributions that we've received. So we just want to put some policy language around that. We also wanted to clarify some of the language we already have relating to when municipalities or boards of education collectively bargain in, so that the time frame for participation is more clear and just includes the authority's ability to request documentation, in case there's any question about that. Couple claims related ones. One relates to the regular work schedule. So as you know, we don't replace benefits based on, or we don't replace wages based on someone's current salary. Our statute says that we have to look at the highest 2 quarters in the base period, which is basically looking at their previous year. But we do have to attribute those benefits to their working schedule. And if they have a regular work schedule, that's easy. If they have multiple employers, or if they have a non-standard work schedule, we have to do a few other steps to come up with what is their equivalent schedule. And sometimes it's difficult to put that together, particularly if they're in that period where they're no longer employed but still eligible for benefits, or if their documented schedule is unclear. So we just want to bolster that language. We also put into the policy that we do need to reach out to non-participating employers under limited circumstances, basically when you have an employee with multiple employers and at least one of whom is not participating. We still need to just sort of validate their schedule so we can make sure that we're accounting for the time properly. We have an existing policy that says if there is a employer reason for an employee not to work, separate from the leave itself, such as a holiday or, like a week-long shutdown at the end of the year, or I don't know if Pratt still does this, but they used to always have that August shutdown, then we don't pay benefits because that employer reason is an intervening event. Well, there are things that may not be an employer reason, but are a intervening event that would prevent us from providing benefits, such as if someone is out of work on jury duty and they're going to court, and that's why they're not at work, if they have military reserve commitments, if they're incarcerated, or other such intervening events. So we just want to make that clear. And then finally, we've been mirroring DOL and how they handle unemployment insurance compensation in connection with severance payments. Previously, it had been our understanding that if someone received a severance payment that required a release of claims, that would not prohibit them from receiving UI benefits. DOL corrected that understanding about a year or so ago. And so we just want to correct that in our policy as well. Shifting gears to pregnancy and bonding. There is a regulation under FMLA that says an individual who's eligible for FMLA leave can take block leave for bonding, sort of without question. But if they want to take intermittent or reduced schedule leave for bonding, that is subject to the employer's agreement about the schedule and frequency and duration. And so we had transferred that employer agreement into our procedures. But now that we're in this and we understand that there's some more differences between FMLA and us than we originally thought, we realized that that employer agreement of schedule is really not applicable to us. If the employee is working in intermittent leave and we can validate that, then getting the employer to sort of sign off on an extra step saying, yes, this is the schedule we approved, is sort of supernumerary to our requirements. So we think we should drop that. We do, on the other hand, want to add the requirement that folks need to tell us specifically when the baby is born so we can appropriately account for switching the medical side to the bonding side. This doesn't really affect the claimant from a claims procedure, but it is possible that there may be tax consequences based on whether the leave is categorized as medical or non-medical. And in order for us to make sure that we are compliant with the guidance that we hope will be coming out from the IRS soon, we do need to make sure that we have that information. We have been treating that bonding leave that occurs immediately following recovery as one claim, and we do not rerun eligibility. We just want to have our language reflect that. And then two other form-related things. The Department of Public Health has an acknowledgement of parentage form. They use that as the basis for issuing the birth certificate, but it's easier sometimes for folks to give us a copy of that than to wait for the birth certificate to be issued. So we wanted to just make clear that we are willing to accept that. And then we have always had a form that we've been willing to accept. It's our own form that the employee will fill out. And we used to call it the certification of birth. That sounds a whole heck of a lot like birth certificate, and it causes confusion. So we want to just change the name of it in our policies to show that it's a documentation of parental relationship, because that's really what it is. It comes up because some of the other forms of proof that we accept, like hospital records, don't list the name of all the parents. And so this is a form that enables the non-birth parent to show the relationship, but we want it to be clear. And then just general cleanup, sort of cleaning up on the grammar side and then cleaning up on some things that we never really engaged in or never explicitly stated. So I'm going to stop sharing. I do have the document if anyone wants to look at it directly, but I just didn't know if you all had any questions or suggestions before we bring it to the board.
All right. Questions, comments? Seeing none, I just have one. Aaron, if you could go back to the pregnancy bonding, the first bullet. It was whether or not employer agreement is required for intermittent or reduced leave. I'm just unclear. What is the Connecticut Department of Labor's view of that? Do they require employer agreement?
Yeah, so we're not changing the FMLA side of it. So and Ellen, you can correct me if I'm wrong, but I believe Connecticut FMLA says the same thing as federal FMLA, which is that bonding on a block basis is kind of the right if you're eligible.
Right.
But bonding on a reduced or intermittent basis requires that agreement between the employer and the employee. It enables the employer and the employee to work out the schedule. We're not changing that piece of it. We're simply saying that in order to get the benefits for the leave from us, so while you're out of work, we're not going to ask for that sort of extra validation that, yes, this is a schedule that the employer has approved. Candidly, if the employer hasn't approved the schedule and the employee is out of work, the employee is sort of jeopardizing their job protection.
Right.
But that's outside of our scope. So we're kind of
Okay.
just trying to stay in our lane.
Okay. Yeah, that was my question. But you answered it. Thank you.
Okay.
Anything else? All right, so the next step for these policy revisions is to be presented to the board on Thursday?
Correct. As long as you guys are okay with that, we would like to present it to the board on Thursday and ask the board for a vote to authorize us to post it for public comment.
Okay. Any concerns at all about that process? All right, good. I think
Great.
that's the road we're on. Moving to the next item, discussion about proposed revisions to finance and accounting policies. Dave, can you lead us in that discussion?
Yes, Mike, thank you. Good morning, everybody. So annually, we review the finance policies and update them as necessary because changes happen during the year. These changes, because they are finance related, were reviewed with the finance and audit committee already. I realize a couple of you are on that committee, so you may be experiencing deja vu while I go over this. Whether that's on the Dionne Warwick side or the Crosby, Stills, and Nash side is up to you. But for everybody else, this will be the first time. Having said that, as I share my screen, I will let you know that if the computer cooperates with me, there we go. I will let you know there weren't that many significant changes during the year. But having said that, let's review them. Everyone can see my screen, correct?
Yes, we can see your screen.
Okay, thank you for the clarification. Okay, the more significant updates were, number one, the authority has updated its annual review due date to September 1st. This was a change that was approved by the legislature early in the year, so that all our annual reporting is now on September 1st. It had previously been on July 1. We moved it later, again, because it was easier to have everything on the same due date. And number two, we were able to report everything on a fiscal year basis with the September 1 date. The other significant update was that our credit card expenses are now approved in Bill Spend and Expense module, which we implemented this year. Bill Spend and Expense has been an improvement for us because it automates the workflow of approvals, documentation. It syncs automatically with QuickBooks. And so now there's no need anymore for a manual journal entry, which had previously been stated in the policy. So we made that change. Other clarifications we made in the finance policy was that the audited financial statements are presented to the board. They're not approved by the board, which has been happening all along, but we changed the policy to reflect that. Also, the administrative fee was originally envisioned to be calculated as a percent of contributions. But as the finance as the Finance and Audit Committee had pointed out a year or so ago, the expenses of the authority tend to be more fixed, while the contributions can be more variable. So it made more sense to determine the authority's fee based on expense history, which is what we're doing. And that change had been made in the policy last year. What hadn't been changed is the reconciliation of the fee. There's no longer a need to reconcile the fee because it's not based on a percentage of contribution. So there's no need to reconcile actual to budget. Having said that, the fee is presented every month, as most of you probably are aware when I review the financials, and actual to budget is always there. And if there's any variances, they are explained. Other minor updates include we formatted the document just to make it a little nicer, neater, and cleaner. My thanks to Liliana Andujar and my department for spearheading that. We also clarified certain financial abbreviations like generally accepted accounting principles stands for GAAP. Finance people know that. Other people are like, what does that mean? So we put them in there and define them. We also updated the annual operating budget's internal schedule so that it agrees with the deadlines in the plan of operations, which had been updated previously because the schedule that had been in there before actually didn't work with the timeline that was in there that was presented. So we cleaned it up to make sure that it worked on a go forward basis. And then finally, we updated the our journal entry template for our daily deposit of contributions because we're regularly fine tuning that during the fiscal year. So we wanted the latest and greatest in there. So those are the updates to the finance policy. Again, like the previous policy, we'd like to bring that to the board this Thursday, actually, and present it to them, and then for public comment, and then ultimately for approval. So I'm happy to take any questions at this time if anybody has them.
Questions, comments, or concerns about presenting these policies to the board on Thursday? Seeing none, Dave, I think we're good to go for Thursday.
Great, thank you.
Okay. Thank you. Moving on, Aaron, back to you for an update regarding the contribution rate change policy, which had been posted for public
Great.
comment.
Thank you so much. I have a slide on that as well. So we posted the contribution rate policy, which is separate from actually deciding the contribution rate itself. The policy is meant to identify the factors that the board considers when establishing that rate. So that was posted in the Connecticut Law Journal. We also shared it with the advocacy organizations with which we work, as well as the Insurance Association of Connecticut, to let them know to look for it. And in the 30 plus days that it was out for public comment, we received 2 comments. First, from Connecticut Legal Service Programs, suggesting first that they thought we should keep the contribution rate the same, which is sort of in legal terms dicta, because it really wasn't the issue. But they also suggested that we add explicit language in the policy to say that we consider the adequacy and calculation of current benefit levels. We referenced the need to make sure we can continue to pay benefits, but they're suggesting we also consider the adequacy of the benefits, and including making sure that we include potentially stronger language about the impact of the rate on the overall health of the trust fund and its ability to address long-term economic shifts, which we do have to some extent, but we can talk about whether we need to bolster that. We also heard back from the Insurance Association of Connecticut, which passed on a comment from one of its members, saying that they recommend that we kind of look at those other state programs, including some of the more mature programs like New York and California, and recognize that as people become more aware of the program, we can see increased utilization. They also pointed out that even for mature programs, there was a good deal of volatility after the pandemic, and they also recommended not decreasing the rate and sort of just being very conservative in order to be prepared for the future. So those were the only two official comments that we received. Unofficially, we also heard validation that the board's intuition that making the contribution rate decision as early as possible would be appreciated by various stakeholders. Recognizing that as early as possible still requires us to make sure that we have good data. But they all thought that getting the decision as early as possible, preferably by September, would help them make their decisions and roll out any changes. So that's kind of what we got. I can share the actual policy language if anyone would like to see that, just to compare it to the contribution to the comments.
Why don't you put that up?
Sure. I just have to find it on my. Let me do it this way. Let me put it on my screen and then I'll share. There we go. So this is what it says right now. So we do reference the need to make sure that we can continue paying benefits in the short and long term, and to make sure that the funds are sufficient to address a variety of economic conditions. But if there's any language that you think should be bolstered, we can always do that.
Well, I just have one observation. I mean, the comment that we should take into account the adequacy of the benefit. We're already providing the maximum benefit allowed by statute.
Yes, so I think in that context, they had, I think it sort of is the maximum benefit allowed by statute good enough. I didn't include this as part of the excerpt, but they referenced their acknowledgement that any change to the benefit rate is a legislative change.
Yeah.
But I think the idea here was, if the board has a belief that the benefit rate itself is something that we should be talking to the legislature about increasing, we wouldn't want to take any steps to make it impossible to increase on the contribution side.
Okay. And I'm not sure that belongs in this policy. If there's a sense among the board that the benefit rate is inadequate, we have kind of a legislative arm, right? A direction we could go to present that for consideration. Personally, I don't think we need it in this policy.
I mean, that's absolutely a point of view, and that's something for the board to consider. I think the concern is you want to be acting in concert. So, because it's difficult, right? The timing is difficult and the control is difficult. We don't have control over the benefit rate, and the timing of the contribution rate is the fall. The legislature has control of the benefit rate and they make their decisions in the spring. So I think that's just sort of something that we have to work through.
All right, anyone else have questions or comments? Anyone think we ought to modify anything based on the comments we've received? See, I'm somewhat comforted that both of them point out we need to be conservative. They both said we shouldn't increase it. They both said we should be, referencing the pandemic. We ought to be concerned about, the unknown unknowns out there. So I think those are all very, very good and appropriate points. I think those are already embodied in the broad language we have in the policy. I don't know if anybody, I don't think we need to change anything, but if anybody has any suggestions, we should talk about it. All right, hearing none. So what's the next step with this?
So the
Yeah.
next step is this. I'll share with the comments with the full board on Thursday and then ask the board to see if anyone wants to make any changes to the policy statement based on those comments. And then we'll ask the board to adopt that policy on Thursday. So that'll be the hope will be that we'll have a full policy by the end of the day, Thursday.
Terrific. Okay, can we move on to the next item?
Mhm.
Any old business anyone wants to raise? Seeing none, any new business? Seeing none, may I have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? The motion carries. The meeting is adjourned. It is 9:27 a.m. Thank you very much for your time this morning. Enjoy the rest of your day.
Thank you, everyone.
Thanks,
Thank you.
everybody.
Bye-bye.